Now, our second segment on In Your Interest, we're looking at a moment that is rare in Indian legal history. The Supreme Court has questioned its own verdict. Not a lower court's order, not a high court's ruling, its own. And we're looking at a legal battle that sits at the very intersection of national security and individual liberty. It concerns the case of Umar Khalid, but the implications reach far beyond just one individual. A two-judge bench of Justices B.V. Nagarathna and Ujjal Bhuyan raised serious concerns about a judgment delivered by another two-judge bench of the same court earlier this year. A judgment that denied bail to Umar Khalid and Sharjeel Imam in the Delhi riots conspiracy case. Both men have been in jail for over 5 years now. Their trial has not concluded. In 2021, a three-judge bench of the Supreme Court delivered a landmark ruling in a case called Union of India versus K.A. Najib. That verdict established a clear principle that when an accused has been in prison for a very long time and the trial is nowhere near completion, that prolonged incarceration by itself can become a valid ground for bail, even under the stringent Unlawful Activities Prevention Act, the UAPA. Today's bench said that this 2021 ruling is binding law. It cannot be diluted, it cannot be sidestepped, and critically, a bench of equal or lesser strength cannot simply ignore what a larger bench has already decided. The bench put it plainly. What it cannot do is quietly set that precedent aside and proceed as if it does not exist. And that, the court suggested, is precisely what happened in the January order that denied bail to Umar Khalid and Sharjeel Imam. The court also raised a concern that goes to the heart of how UAPA bail hearings work in India. It warned that pre-trial detention cannot be allowed to take on a punitive character, which means that the time a person spends in jail before being found guilty cannot effectively become the punishment itself. And the right to a speedy trial, the court reminded, is a constitutional guarantee under Article 21. It does not disappear simply because the accused has been charged under the anti-terror law. But here's where the picture becomes more complicated, because the January bench that denied bail to Khalid and Imam also had its own reasoning. That two-judge Supreme Court bench of Justice Arvind Kumar and Justice N.V. Anjaria held that Khalid and Imam played a central and formative role in what the Delhi police calls the larger conspiracy behind the February 2020 Northeast Delhi riots. It drew a distinction between those who were peripheral participants and those who allegedly conceptualized, directed and mobilized unlawful activity. It also held that a coordinated chakka jam designated to paralyze a city could qualify as terrorist act under UAPA, not because weapons were used, but because of the intent and the actual impact. And at the heart of this debate is Section 43D, Part 5 of the UAPA, which allows bail to be denied if the accusations appear prima facie true. In simple terms, courts at the bail stage largely rely on the prosecution's version through the charge sheet and case diary, while the defense has very limited scope to challenge the evidence in detail. And the situation became even stricter after the 2019 Vatali judgment, where the Supreme Court said courts should not conduct a mini trial during bail hearings. This means the prosecution only needs to establish basic plausibility, not prove strong enough for conviction. Critics argue that under such a framework, securing bail under UAPA becomes exceptionally difficult. And the result is that many accused in UAPA cases spend years in jail before trial meaningfully progresses. Critics have long argued that in such cases, the process itself begins to feel like the punishment. And the Supreme Court has now indicated that prolonged incarceration alone cannot become the norm under the law. If courts rely primarily on the prosecution's version at the bail stage, does the balance tilt too heavily against the accused in the UAPA cases? If disruptions like protests or chakka jams are framed as terrorist acts, where do we draw the line between legitimate democratic dissent and a threat to national security? And can prolonged pre-trial incarceration undermine the principle that an accused is presumed innocent until proven guilty? With us on the broadcast, Kapil Sankla, Advocate Supreme Court, and Dr. Rajiv Nanda, Senior Advocate Supreme Court, with us on the broadcast as well. Dr. Nanda, many thanks for patiently waiting here. Just to get the snowball rolling here, the Supreme Court is effectively saying that smaller benches or similar sized benches have diluted the K.A. Najib judgment. Is this a rare institutional correction by the court itself? How important is this for both sides of the bar? If the trial itself takes 5 to 7 years, should the accused remain jailed throughout? What's your assessment and standing on this?
As far as the question of the bench, questioning its earlier order passed by a smaller bench or a larger bench, this is not the first time that Supreme Court has done this. Supreme Court has been reconsidering or has been questioning its earlier judgment. Keshwananda Bharti was the best example where the Constitutional Court of the 5 judges, then the 7 judges, then the 9 judges, and the 11 judges, it was referred. So it is always that Supreme Court can review its earlier judgments if the later benches find that the earlier judgments were perhaps not correct in law. Then, in the interest of justice, that these can be reviewed. Now, as far as the question of UAPA bail is concerned, here it is not a simple case of bail.
Then, Dr. Nanda, why talk about dilution? Why use the words like sidestepping by Justices Nagarathna and Ujjal Bhuyan? I mean, help the viewers understand why use those particular adjectives this time around.
So it is not, no. It is don't go by the words literally, diluting and all that. They were only saying that the two-judge later bench cannot see the earlier three-judge bench, cannot overrule it in a way that they can take a different view. So it is not the question of diluting, maybe looking at it from a different angle. That was the point which the bench was making. It is not that saying diluting doesn't mean literally here. It is only a question which the present bench has raised, that the earlier two-judge bench, which they are saying has been as said, diluted, has looked into the law of bail by the Supreme Court three-judges bench in a different way. So they say that this cannot be done. If it is to take a different view, then a larger bench has to be constituted. It was earlier, the main judgment was by three judges, then it should be referred to perhaps 5 judges. This is what the current bench has held.
But Dr. Nanda, you see, when it comes to the UAPA, it's always, embroiled and tangled with a lot of politics. We're going to keep that aside. Let's look at the legal aspect of it all. If conviction rates are so low when we're talking about the UAPA, are we over-incarcerating? What's your assessment on that front? Is suspicion becoming sufficient for years of imprisonment? I mean, these are the questions that came up today after the hearing.
The UAPA is an act which has been legislated in a way that till the time it is there on the legislative book, you can't help it. There are 3 bars. It is unlike the normal case of bail, where the longer incarceration can entitle accused for bail, or the bail is the normal rule. The incarceration should not be there during the trial. UAPA minded, there are bars under 43D. The prima facie bar is there. That if the prosecution prima facie establishes before the court that the person charged is guilty, that minded the word is only prima facie. The prosecution may not be in a position eventually to get the conviction because of lack of evidence. But if they prove prima facie that there is a case, then yes, the bail can be denied. Then there is a second thing which is not there in the normal cases, which is called the prosecutorial veto. The public prosecutor has to be given a fair chance to oppose the bail, that this is a case where the UAPA is applicable and the person charged is guilty. And the third one is, of course, the burden here is in a reversed way. Normally, it is on the prosecution to establish that the person is charged, the person charged is guilty. Now, here in the UAPA, the burden is reversed. It is for the accused to say that, no, look, what I am charged with is not the prosecution's case is not correct. I am innocent. So the normal rules are not applicable here.
All right.
Now, as far as finding them guilty and their longer incarceration and ultimately not the charges not proved, that is on
what I make of this, Dr. Nanda, what I make of this, and I'm going to bring in Mr. Sankla as well. Advocate, do stay on with us. It seems like national security, from what I've understood, what you have suggested, automatically overrides personal liberty, and for a good long period of time. Is that so, Dr. Nanda?
Of course, yes.
Okay. What's your assessment, Advocate Sankla? If courts begin liberalizing bail in UAPA cases, does it risk weakening India's anti-terror framework?
Can I just answer the question that you had raised first regarding delay, because it's connected? And to that, I would like to say is this, that you see, delay in trial is a systematic issue across the Indian criminal justice system, all across India, not unique to UAPA. I mean, it's even there in a 138 Negotiable Instrument Act case. Let's be reasonable. The only difficulty with the UAPA case is the sheer magnitude of thousands of documents, the encrypted devices, the forensic extraction, the difficulty that, because this is a very large conspiracy, there are conspirators at large who perhaps are trying to systematically destroy evidence or witnesses, etc., to protect the witnesses. There are multiple accused. There are multiple lawyers involved. There is interstate coordination that is required. And so, because of these complexities, yes, there is delay. But that's not just unique to UAPA because it's UAPA. It's because of the sheer nature of the case. Now, as far as the second question is concerned, please do understand that national interest should trump everything else. And I do understand that Article 21, your right to life, speedy justice, all of that is sacrosanct. And nothing can trump over your fundamental rights. But there is also a responsibility of the state to protect its citizens. And that responsibility is much higher, because after a bomb goes off somewhere, you cannot in the hindsight say, oh, if I would have done that, I would have protected my citizens. And that's my answer to your second question.
So ordinary bail principles can't really apply to extraordinary security threats, and that's the way it has to be. It's coincidental that there is a systemic issue, there is pendency of cases, there's a lot of paperwork, different sets and batteries of lawyers, all of that. That's the logistical and the systemic problem that is coupled with this. But the bottom line is that when it comes to national threat, well, your fundamental rights can take the back seat.
I did not really say that. What I said was that your fundamental rights are sacrosanct. Yeah. But there's a larger issue of the state's responsibility to protect its citizens. Because the citizens also have a fundamental right when you pay your taxes, when you're a citizen of a country, that the country protects you. And the country protects you how? Through the state mechanism. And so while liberty is fundamental, but liberty cannot become detached from societal security. The Constitution protects not only the accused, but also the innocent citizens who have been threatened by organized violence. And that perhaps is the fundamental question here, that whether the larger interest can trump over an individual interest or not.
The larger interest over the individual's interest. Dr. Nanda, you see, indefinite incarceration with all these problems, that Advocate Sankla has just mentioned to us, does it justify the indefinite incarceration? I think that's the operative part of this debate and what was observed by the Supreme Court today as well.
No, it is not indefinite incarceration. The trial is going on. It is not the number of witnesses.
But then what do we learn from the K.A. Najib case? What are the key takeaways from that particular case?
See, that judgment is applicable in the facts and circumstances of that case. Let us not say that UAPA or any other law is not applicable or the bail principles are applicable universally. It will vary from case to case. As I said, in the ordinary manner, the rule is bail and not the jail. The incarceration should not be there during the trial. And here there are at least, in the UAPA, there are at least 3 barriers in the grant of bail. So if the bail is denied on merits in a particular case, that does not mean continuous incarceration because of UAPA. It is because of the legislative provisions that there is prima facie case, as I said, the prosecutorial veto, and then the reverse burden. These are the 3 legislative bars. You cannot say that there is a continued incarceration. The voluminous evidence to be examined is perhaps the cause for delay here. It is an administrative delay. It is not caused because of state. Yes, if perhaps in a particular case, accused can bring on record that it is the state which is delaying, despite the fact that I am incarcerated for such a long time, it is the state which is deliberately delaying. Yes, perhaps there can be a case for bail.
Okay. Advocate Sankla, when we're trying to navigate the legal alleyways, the critical assessment that process as a punishment is being institutionalized, how does one navigate that, that very, very tricky alley?
Well, it sounds very nice for all political parties, but in terrorism and organized destabilization of a nation or the government, waiting for a final unfortunate explosion killing thousands or hundreds of people before intervention would itself be a failure of the state, and you'll agree that, right? So as politically charged this slogan might be, or as attractive it might be, But unfortunately or fortunately, it is legally inaccurate, and I'll tell you why. Because UAPA cases still undergoes judicial scrutiny at every stage, and more so at the stage of remand, at the stage of cognizance, at the stage of charge, bail, trial, appeal. The standard under section 43D5 is not an automatic conviction. It is a legislative recognition of the gravity and the complexity of a terror-related case. And I would invite your attention to this, perhaps, that nobody is talking about. That perhaps if you could go through the order sheets, you would perhaps get to know how many times the prosecution has delayed the matter and how many times the counsels, the various counsels of the accused have delayed the matter. See, we have to right now be cognizant of a very important fact, and which is this, that the Honorable Supreme Court, even till date, has not struck down the checks in section 43D5 of UAPA. The Honorable Supreme Court has not declared UAPA to be unconstitutional. The court has not held that all UAPA accused deserve bail. It has reiterated a principle which is a long-standing principle, which is bail before jail. And no party can be incarcerated indefinitely. And as the learned senior counsel has also stated, it is not a case of indefinite incarceration. It is not even a case, in my humble opinion, where the state has taken undue time. It is a case because of the very complexity of the case and the tens and dozens of lawyers involved, that there have been delays on various fronts. And that is a fact which will be dealt in a transnational funding sleeper cell case, where there is a larger conspiracy and conspirators do not know how they are connected and who the puppet master is.
And Dr. Nanda, what about, the conviction rates, the acquittal rates, acquittal rates reportedly being very high, conviction rates not so much. What's your assessment on that front? Because that particular number and figure is being weaponized by those that are critical of the act.
Don't mix up the two things of conviction rate under UAPA and the normal criminal law. There can be less conviction in the normal criminal matters also. As I said, in the UAPA, it is very complicated evidence which is brought on record, and it is very difficult to fetch because the chain is woven in such a way that it is difficult for the prosecution to bring on record the entire evidence. And in the absence of such evidence, the accused gets free and they are not convicted eventually. But then that does not mean that there is a failure of the UAPA law itself.
All right. Advocate Sankla, before we wrap this up, your final comments?
You see, conviction rate alone cannot determine the necessity of an anti-terrorism law. And that is my view. I'm on the defense. I would always be on the defense, but that is the fact of life. Many cases involve preventive disruption of networks, of understanding national security issues that are way beyond your and my understanding. The state cannot afford the luxury of a hindsight in a terror-related investigation. And therefore, under those circumstances, let us not look at conviction. Let us look at the protection that such a law has brought in. And I think it is better that we have stronger systems where perhaps the conviction rates are low, because the test of judiciary is testing every investigation than otherwise.
All right. So national security, it does not automatically override personal liberty, but the judicial system, and of course, when it comes to national security, we don't have the luxury of hindsight. We don't have cat in retrospect helping us out, and protection of the law is what we need to focus on. I think we're going to leave it at that. And like Dr. Nanda said in his opening, submission, that time and again, the Supreme Court and all the benches, they keep on reviewing and revisiting their own orders. So nothing new or, breaking that's happened on this particular front. Dr. Nanda, always a pleasure to have you with us. Advocate Sankla, Supreme Court advocate with us on the broadcast as well. Many thanks for taking out the time. With that, it's a wrap on this edition of In Your Interest. We're going to catch you again tomorrow. Many thanks for watching.